Hello, and welcome to the Simpler Education Series webcast. Today's webcast is titled, Why and When to Use Peer Review, Understanding the Legal Significance, Benefits, and Challenges, with Brian Bettner. At the end of this session, we will have time for a formal Q&A, but feel free to ask any questions as they come to mind via the chat box located on the right side of your screen. You will also be able to download the archive of today's webcast and its slides at simpler.com soon, and will receive download information via email. Next slide. The Continuing Education Series is certified by NAMS and is sponsored by Simpler Compliance and Credentialing for Healthcare. Next slide. We are so pleased to have Brian as our speaker this month. Brian is a shareholder with Hall & Render Killian Health and Lyman, which is the nation's largest firm focused exclusively on the healthcare industry. He is the vice chair of the Medical Staff Credentialing and Peer Review Practice Group of the American Health Lawyers Association, and also regularly speaks on medical staff issues across the country for various organizations. I'm sure many of you know him, and I'd like to turn it over to him now.
Thanks, Callie. Good morning or good afternoon, everybody. I hope you're doing well. So I really appreciate the opportunity to interact with each of you today, and I want to repeat something Callie had said about inviting questions or comments throughout. My approach is to be very interactive and be as worthwhile as possible for you, so please do not hesitate to ask questions at any point. You can understand, you can enter a question online here, and then we will react to it real time. I'll enjoy the dialogue with you, and so I want to make sure we don't miss any issues that might get traction at the time they come up. So again, please don't hesitate. So the entire concept, we've got a big topic here today for you. The why and when to use peer review, understanding legal significance, benefits, and challenges is a huge topic. And it is a lot to cover in 1 hour for sure, but I think we can cover some of the more salient points as you look to reinvigorate your quality and peer review programs. I'm going to break this discussion into really 4 general areas that we'll work through, and those are what we mean by peer review, why perform peer review, the peer review reality, talking about peer review of today or yesterday, if you will, and then the peer review of tomorrow. And I want to share with you some recommendations and considerations, some low-hanging fruit. But as I said, it's a big topic, and there's a lot to cover, so don't hesitate to bring up something you'd like the group to collectively explore. So what do we mean by peer review? And I ask that question, I pose it like this, because the term peer review is loosely used. And when we peel back the layers of the concepts of peer review, in my experience, it's also poorly understood. I have worked with well-intentioned, senior, exceptionally competent healthcare leaders and medical staff leaders who carry on concepts or understanding of peer review for years, if not decades, based upon earlier models, and it can frustrate some of the things we're trying to do in the 21st century here. But the term peer review itself, I mean, let's look at just the basic American Medical Association definition, right? It's relatively straightforward. The foremost objective of medical peer review is the promotion of the highest quality of medical care. Okay, well, what does that mean? And we know for a fact, when done right, an invaluable part of our healthcare delivery system, unquestionably. But the concept of peer review, so that we are clear, and this is we're going to start working through some of the details, it is a byproduct of state and federal law, and principally state law, but there are aspects of it of federal law that drive this. It's not what we feel it is necessarily. Applicable state statutes, they will describe and define the purpose of peer review, who is and is not a peer reviewer, the procedure that must be followed, what aspects of peer review are confidential, and under what circumstances immunity is available for your activities. And this is all rooted in the intent. Why do we even have peer review statutes? So why do they even exist? So the origin of every state's peer review statute, and every state has one, and the Healthcare Quality Improvement Act of 1986, which established the National Practitioner Data Bank, it basically did 2 things. It established the data bank that you all love and are familiar with, and it established the process that healthcare entities can go through to earn immunity for the actions they take on the privilege and quality front. And it outlines what the intent is, what's the purpose of their goal. And the goal really is to promote peer review. Let's get healthcare organizations who are qualified, at least from a Healthcare Quality Improvement Act standpoint, to actually perform peer review. And this is a mid-80s model on this, not a 2016 model, and we'll talk about that here in a few minutes. But the concepts that virtually every state's peer review statute reaches, including Healthcare Quality Improvement Act processes, is this entire continuum of quality of care. It's everything. Credentialing, privileging, evaluating complaints and concerns about a provider. So every well-structured peer review process, and I'm using that term loosely to get this point across, it applies to the entire quality assessment process. Absent some goofy state-specific carve-out, it should apply to everything. And we tend to confuse it around one-off fallouts of care, sentinel events. That I see that from time and time again in various organizations. It is critically important for you to understand that the devil is in the details on peer review. And here's what I mean by that. The concept of what is and what is not peer review is largely a matter of state law. There's not really, if you take away patient safety organizations, there's not really a federal peer review statute that affords confidentiality. The federal law affords immunity if you follow a certain peer review process, if you will. But immunity is all state law specific. In every state, virtually every state requires on the very discrete technical requirements. There's a lot of activity that happens in random Wednesday mornings across hospitals and physician groups across this country, and it feels like peer review. It feels like quality. What do you mean? That's the chief medical officer. That's the department chair. But what really matters when you scrutinize peer review activities, and this normally only happens in litigation, but when you scrutinize peer review activities, every state court looks at the very minute elemental details of whether the process you followed, either for confidentiality or immunity in some cases, followed the letter of the law. And here's why that's a problem. And I use this expression all the time, and this happens in healthcare regularly. It's not a problem until it's a problem. We have very loose quality activities all the time, whether they involve VPMAs and CMOs doing the heavy lifting for the MEC on any given day, or various hospital quality initiatives where the committee or the individuals don't technically meet the state's peer review statute and all its various elements. Maybe it might be activities in outpatient or freestanding physician group settings. Many states, for instance, don't allow physician groups to form peer review committees. So it's not a problem until it's a problem. And it becomes a problem when we have a patient care event or there's some other untoward litigation that we have to deal with. And then we really learn whether we follow the correct process. We often, when I say we, I'm referring to the healthcare industry as a whole, we often initiate quality activities across many platforms. Today, with mergers and acquisitions of hospitals and system-level activities, multiple hospitals, ACOs, clinically integrated networks, we generate peer review information in a million different settings, and we share it loosely. And we look at each other like, well, what do you mean? This is quality. This is what 2016 healthcare is asking us to do. The problem is hardly any peer review statutes have been updated to accommodate where we are being pushed. And so in reality, a lot of the activities, and I see this all the time within hospitals, medical staffs have a quality process and quality committees, and hospitals have a quality process and quality committees. And when we scrutinize the hospital's quality process, we find out that it actually doesn't meet the requirements of a state's peer review statute. It doesn't meet the elements, but it's never been a problem. It's never come up. And it's never come up either because the infrequency of the kind of litigation that may raise that as an issue. It may not come up because the plaintiff's bar suing us in malpractice and negligent credentialing actions doesn't ask the right questions or doesn't know what they ask for. And in my experience, they really don't understand the process, so they don't know what to ask for. But the state-specific requirements to keep in mind are many peer review statutes only apply to certain provider types. Specifically, they list hospitals, nursing facilities. Some will exclude or include physician entities, for instance. They will contemplate a specific origination, who can form the peer review committee, what the composition of it is. There are some states have described composition requirements. A certain percentage of the committee has to be a licensed healthcare provider. And we find out that was a hospital quality committee with 6 nurses on it, and 4 of them are professional administrators today and gave up their license six months ago. Well, that doesn't feel like that's a problem. Well, it's technically a problem because every state court would not give you privilege for their activities. There may be purpose requirements. It may or may not contemplate sharing or legitimate internal business usage. What I mean by that is when most information is generated, the way peer review laws were written 15 years ago, they contemplated the very traditional model of a medical staff, an executive committee, a quality committee, and everything they did and generated would stay within the confines of that. None of those peer review statutes contemplate what's happening in healthcare today. They don't contemplate networks. They don't contemplate the hospital's employment of more than 60% of its employers. They don't contemplate any of that. So the whole concept of legitimate internal business usage is a challenge for many states, and yet we share it anyway. And then I get back to the point. It's not a problem until it's a problem. It's really important, though, for you all who work within this day in and day out to understand where some of the pitfalls are, where some of the risks are, as you start to elevate your quality programs for some of the reasons we talk about in here in a few minutes. The peer review statutes typically afford extensive confidentiality. That's all very state level driven. And what they allow to be confidential is typically described either in the statute or in the various state courts that have reviewed it. And they also afford usually extensive immunity. And what I mean by immunity is protection from civil damages for your actions if they're done in good faith. And I'll make a point here about the concept of what's privileged and what's not privileged. The last thing we want to do is for a healthcare issue, and I say this being on the healthcare administration side, you don't want a state court, a state circuit court judge evaluating healthcare activities. The reason why you don't want that, this isn't about liability. It's because they have no idea. They don't understand the industry. They don't understand what you do on a random Thursday afternoon. They don't understand healthcare. They don't understand medical staffs. They don't understand the concept of quality review. And so most state court decisions around the concepts of peer review are based upon layman positions on things. And that has been problematic over the years as the industry is, quite frankly, not well understood in state courts. So why do we perform peer review? I mean, why do we do it? I'd like to think that we do it for quality assurance, for performance improvement, for patient safety, to provide the best possible care that is available to our patients, our community, our loved ones, et cetera. But and many organizations do, don't get me wrong, or at least individuals with the organizations do, but we probably largely do it because it's required. It's required by the Medicare conditions of participation for hospitals, if you're a hospital. It's required by accrediting organization elements of performance, regardless of what organization you're accredited by. It's required by state hospital licensure laws or other entity-type licensure laws. The Healthcare Quality Improvement Act doesn't require it, but if you want immunity, there are certain procedural requirements you've got to follow. State professional licensure laws, like medical practice acts, commonly address the concept of quality review. State case law is probably the most important part. I could pull most of your state peer review statutes and they are a page or two long, yet we have 100 cases where layperson judges and juries have attempted to interpret that, and those cases supplement every statute that we ultimately have to implement. Then you've got your policies and bylaws and various rules and regulations that we can be held accountable to as contracts or otherwise. And then you can't forget commercial insurance or managed care populations, or managed care obligations. We have various contracts either through narrow networks or clinically integrated networks in which a managed care process may dictate certain quality reviews upon us. So let me focus on a few very important aspects of peer review. Why you do it, what the laws are designed to accomplish in some respects, and what benefits they afford. And the benefits are significant. And I'll start with peer review immunity. Immunity is intended, the concept by even granting immunity, saying you cannot be held liable for civil monetary damages if you perform good faith peer reviews intended to encourage you. If you've got to make a tough call against Dr. Smith and Dr. Smith sues you because they don't like the outcome, you approach that in good faith, you should have some level of confidence that you will not be held responsible, at least financially. And that's the purpose of immunity in the most general sense. And it typically takes two general forms: immunity against civil monetary damages and absolute immunity. And absolute immunity is a little bit more rare in this setting. A handful of states have specific absolute immunity scenarios. But usually it's about immunity against civil monetary damages, which means if you're sued, most state peer review statutes don't prohibit lawsuits, but they'll protect you if you are sued. And immunity is not a given. We got to keep that in mind. It typically has to be earned through a host of issues we'll talk about right now. State statutes generally afford immunity where peer review is conducted in good faith, meaning we are intending to address a quality or patient safety issue to protect patients or to protect colleagues within the organization. And this is typically presumed, meaning the burden, most statutes say the provider has to, the subject provider, if you will, they have to demonstrate, they have to show factually that this is just out to harm them. This is not in good faith. It's not about quality. It's about some other reason. State immunity, as I mentioned a minute ago, does not necessarily preclude judicial review, which means being reviewed by a court, or injunctive relief, which is the same thing as suing and asking for something specific to happen. Most states adopt a doctrine that allows courts to review decisions, peer review decisions, but they limit their review to whether the organization followed its bylaws or its organizational or procedural requirements. They typically will not, in the absence of evidence that it was in bad faith, will typically not second guess the decision of a medical staff or of a hospital governing board, because they don't view themselves as well equipped to do that. That's a pretty typical position, and there are subtle exceptions here and there, but by and large, it's a fairly common position taken by state courts. Federal immunity, however, as I mentioned, is afforded by the Healthcare Quality Improvement Act, and it affords civil damage immunity where four certain requirements are met. And in loose translation, those requirements are where an organization, a healthcare entity, it's typically hospitals, but other organizations are eligible, they undertake a professional review action, which basically is a recommendation or a decision that is or will likely affect a physician's privileges, for instance. And if that's, as long as that's taken in furtherance of quality of care, and that's a pretty loose standard. Most courts have said the furtherance of quality of care can be broadly defined and is broadly defined. You have to undertake a reasonable investigation, meaning did you look at all reasonable available information that can be generated or reviewed within the course of this organization? Is the action taken, is it reasonable in light of what you found out during the investigation? Or is it disproportionate? And if it's disproportionate, have you justified why it's disproportionate? And did you extend notice and hearing rights? Essentially, did you tell the person and afford the person a right to certain procedural protections? A fair hearing, an appeal, proper notice, advance notice in front of all those things. And so federal immunity will follow in those circumstances. What's very important to understand is it's a high standard. It's a high standard because it's objective in nature and based on the totality of the circumstances. And what I mean by objective in nature is bad faith. Bad faith is irrelevant. It's all about whether there was a reasonable basis for the action. And as you can imagine, it's a pretty difficult threshold or hurdle for a practitioner to overcome, and that's pretty typically the case. Bylaws compliance is important, but it is not the sole factor. Federal courts and many state courts have adopted a substantial compliance standard, which essentially is, did you substantially comply with what your bylaws require or other policies require? And if you didn't comply with them, can you reasonably justify it? The presumption is usually always in favor of the peer review committee, and I'll give you a great example of following the Healthcare Quality Improvement Act from a substantial compliance perspective. And that's the Poliner v. Texas Health Systems case. The facts are almost 8 years old now, and I don't want to focus on it too long, but the thing to keep in mind with this case is it evidences that where a hospital follows a good faith, even if imperfect process, upon scrutiny, they'll receive the protection of federal law. And in that case, it's Dr. Poliner performed he performed a angioplasty on a partially blocked artery. The medical staff had determined after the patient was admitted to the ICU that he missed another block. An investigation ensued. The bylaws at the time contemplated a concept of an abeyance, which is if you voluntarily sit on the sidelines while we look at this. It played out over a number of months. Dr. Poliner didn't like the outcome or the process and effectively sued the hospital, which is Presbyterian Hospital, and in the district court awarded him $290 million initially. Now, to put that in perspective, there aren't many physician leaders who think that they carry personally or the organization carries that level of liability associated with what would otherwise be routine peer review activity. I'm sorry, I said $360 million. Well, after the process is further scrutinized upon appeal, the appellate court looked at this through the lens of the Healthcare Quality Improvement Act and essentially overturned the determination of the district court, which is a substantial finding because they went through the four-part analysis we just discussed a minute ago. And I'll use that as an example to show that based upon the facts in the role of layperson judges and juries, there is potential liability out there, but if you dot your I's and you cross your T's and the evidence shows it's in good faith, you will have the protection afforded by federal and state law. Now let's focus on the second important benefit to peer review confidentiality before we dive into some of the recommendations and considerations. And that's confidentiality. That's mainly what we keep in mind is, can we protect the information generated during the process? And this is important because as we enter in this new quality paradigm, and everybody knows we look at quality, and every organization is making decisions based upon quality, whether those be reimbursement or credentialing related, we have to understand that our information will be sought. And our only ability to protect the information confidentially, to evidence a good faith peer review process, is to abide by your state's peer review statute and how confidentiality is awarded. The protection really focuses around legitimate peer review activities, and we should maximize those. Like immunity, confidentiality, it's intended to promote effective peer review. You are more likely to be candid during a quality review process if you understand the information will stay within the confines of that process. Is that fair? I mean, we understand that you're more likely to be open about something if you're pseudo-anonymous. The privilege typically extends, and this is by definition, we should not assume the details here, but it typically extends to communications to peer review committees and records and determinations and information generated by or at the request of a peer review committee. A peer review committee is critically important to this process. I can't tell you how many scenarios with which we've been involved or various state case law that have determined the acts of individuals. I don't care what title they carry, CMO, VPMA, section chief, medical director, department chair, what title they carry, chief nursing officer, if we cannot tie their relationship and acts to a peer review committee. It's a fairly common standard that the acts of those individuals, if upon scrutiny don't comply with your state's peer review statute, you won't get the benefits of their activity or their information they generated. Just because they're an integral part of the process, we have to connect them to the way the statute was written 15, 20 years ago. It generally focuses on committees and the personnel of committees, which is why you want to connect them to the committee somehow. And there are all sorts of ways to do it, and we can answer that in the Q&A process if you'd like. But keep in mind, confidentiality is not an option by most state statutes. They mandate that you maintain the confidentiality of it. And the breach of confidentiality could lead to sanctions or loss of immunity, or certainly loss of the confidentiality blessed by the law. There are exceptions, of course. I mean, every state contemplates exceptions, and there are a host of common ones, like the requirement of confidentiality. It can be used, there may be uses and exceptions for legitimate internal business use by some states, to be shared with departments of health, for instance, if it's an adverse event reporting. Some states allow limited access by government, through government investigations, very limited access. Original source documents. So the original information, so a common dispute in virtually every state are whether incident reports are privileged, right? Many states have said they're not because they pre-exist the peer review process. There are ways in certain states to I shouldn't say get around, but to deal with that. But we have to understand that original information that predates the peer review process, assume it's not going to be privileged. Typically, most states allow for a physician to access their peer review file. There may be conditions upon that as well. And the internal business usage issue is a challenge today as we form ACOs and clinically integrated networks, and the hospitals are forming and purchasing and commencing clinics and outpatient centers and freestanding facilities, and we want to look at quality in those settings and how do we share information, particularly where a large percentage of providers are employed today. Can the HR department use this information? And I'll come back to, unless state peer review law allows it without waiving the privilege, it's not a problem until it's a problem. It happens more than enough that a physician whose employment relationship is terminated will argue you had no right to share that confidential peer review information with the HR function of this organization because that was peer review privileged. And that then gets us embroiled in a larger litigation action around wrongful termination of employment. So we've talked about what we mean by peer review. And I want to kind of make sure I focus on this before we move forward. Peer review in its absolute broadest sense should be all of your credentialing, privileging, quality assurance, performance improvement activities. Virtually every state will allow you to do that. So let's not view it as these rogue scenarios where we're isolating a single physician because a case fell out for review. Most of your activities can qualify for peer review privilege in your state. You just have to think through tactically and strategically whether, if you put it within that process, does that limit your use of it? And we'll talk about some examples where that'll be important here in just a minute. So now I'm going to transition to the peer review reality, what I'm calling the peer review reality today, and it's what I come across, and we're all friends, right? So we can talk candidly about what we experience and about how underwhelming our various quality assurance programs are, regardless of venue. But the first challenge with peer review activities, and this is what I just discussed with you, technically it's technical. And what I mean by that is it's not about whether we feel it's privileged. It's not about whether, what do you mean? That's the chief medical officer. Why can't he or she do that? It's all about, are you satisfying the elemental requirements that your state peer review statute requires? And if you're not, are you making an informed decision that, you know what, this was written in 1987, we're trying to do this today, it doesn't really allow this, but we're going to assume the risk. We're going to share the information anyway and assume it's not going to be an issue. It's a very important thought process to go through. Another one is culture, and I'll remind us of this towards the end, but without a doubt, an organization's culture and approach to how we will deal with quality issues, and I don't mean quality problems, I mean even achieving high quality and how we define high quality, it's everything. It's whether you have the ability to change processes, protocols, what you can share transparently and what you can share, whether people keep their jobs or not. And I can give you some examples about that in a few minutes. But culture of the organization and willingness to focus on this issue almost above everything, because of the ramifications we'll talk about, is perhaps the most significant yet intangible hurdle that you have. The whole concept of distrust, punitive history, and so-called sham peer review. I will tell you, I have interacted with peer review committees and medical staffs and hospital administration and physician group administration in hundreds of quality matters. And I know the concept of sham peer review is often mentioned, but I will say you often see what you want to see. And what I mean by that is rarely ever, something may be imperfect and I may not be caught on a process, but rarely have I, and I'll say never, have I seen legitimate peer review. Does someone maybe not fully understand the process and they want to cut a few corners? Maybe, but that's not sham peer review. That means they're being impatient. And we need to get them on back. We got to recalibrate how they should be doing the process. But that's, we can't underestimate the view by a substantial portion of your medical staff, for example, who may be more senior and seasoned, who have bad memories of peer review activities from 20 years ago. It's a significant hurdle in terms of how you approach it. The lack of expertise and training. I don't know a single medical school, and there perhaps is one, and I applaud them if they exist, but a single medical school that has a rotation on medical staff administration and how to perform QA/PI activities. And there is efforts by various organizations to send physician quality champions or other practitioner quality champions to get a training and expertise, but there's generally a lack of broad-based expertise and training in the concept, and it's hard to fit in time-wise. We also have perceived or actual conflicts of interest, right? Having to understand, I will get the question all the time, and it's March of 2016 now, is can we have same specialists in a department perform peer review on other same specialty physicians in the department? And I say, of course you can. Absolutely, of course you can. This perception around conflict of interest is flawed when you're doing it within the granular day-to-day activities of OPPE or OPPE. Sentinel event or nothing. There's an attitude around, well, we perform quality review or peer review when it's a bad outcome. And that's not the way to do it for reasons I'm going to introduce you to in just a couple of minutes here. We have an opportunity now to elevate organizations, and it really has to start with your QAPI process. Inconsistent approaches. Leadership changes every 2 years. They have different approaches for how they want to deal with quality issues. That's a significant problem. Increased time demands on physician leadership. There's a story I share whenever I have opportunities like this because it's very telling of the mindset of many physicians today, and it's legitimate. It's absolutely legitimate, but the response by a colleague is legendary. So in a quarterly medical staff meeting I was participating in, we were discussing the impact of healthcare reform on physicians and getting into some of the various machinations and details on that. And in the middle of it, there's always a contrarian in the group, and I respect that. And he raised his hand and said, this is absolutely ridiculous. I'm not getting paid to do these things. There is no CPT code for at that time, it was a case management scenario in how to do quality assurance and patient engagement. And he said, I don't get paid for this. And his colleague slapped him on the arm and said, but Bob, you won't get paid unless you do it. And that was an epiphany for many in the room to understand the healthcare industry that they cut their teeth on is not the healthcare industry that we are becoming, good, bad, right, or wrong. And we have to understand that it's changing. In many respects, from a patient standpoint, it's changing for the better. Refusal to refer to or obtain consults from problematic provider. I see this all the time. If we really focus on this issue, it's going to flaw or taint our relationship, and how do we deal with that? That's an unfortunate reality of the profession. We often have to have very direct and blunt and professional, courteous discussions with medical staff leaders who understand that role is not all about dinners and golf outings. It often has to make very tough decisions, and most medical staff leaders very well understand this. But there are some that don't fully appreciate that with the benefits comes some very challenging, crucial conversations, if you will. And I say, and so on. Insert your own challenge there organizationally or within your market. Put simply, most or many QAPI programs and peer review programs just get by. We may do an okay job at capturing data and assessing data, or I shouldn't say assessing, but reporting it. But one of the most underwhelming aspects of a hospital or a healthcare organization's quality assurance performance improvement program is that I rarely see the data being captured deliberately being used to improve the quality of care across the entire organization. This might be a very robust hospital quality program, generates a lot of information, and that information is never shared or utilized in a meaningful way throughout the credentialing and privileging process. This is about lifting all boats. We want to elevate the organization. And typically, we look at it only when we have to deal with problems rather than improving care. And that's why many programs just get by. So what happens when things don't go correctly? What happens when we make mistakes with a peer review process? Most days we get away with it. And I don't say we get away with it nefariously, like we're trying to get away with it, but the reality is there are implications for failed or flawed peer review processes, and they're not a problem until we realize we are now embroiled in 6 years of litigation, and this is the biggest mess you can imagine. How could we have prevented this 6 years ago? And some of it is institutionalizing in your operations, in your process, some issues. So let's talk about what the implications might be so we can paint a big picture for you. and you can use in different educational offerings in your organization. In no particular order, we've got a failure to achieve the purpose, right? I mean, increased risk of harm to patients, increased risk of harm to colleagues and other hospital personnel, particularly if it has to do with contamination, disease management, or behavior issues, missed opportunities to rehabilitate a provider, and then it gets too late. Financial implications. I should have flashing lights around this. Decreased reimbursement, loss of business, and cost of litigation are overwhelming drags on most healthcare providers. I'm going to describe for you in greater detail a not well understood impact of quality in relationship to reimbursement. It is critically important that organizations understand that their quality assurance performance improvement activities, i.e. peer review in its largest sense, have a very direct relationship to the financial performance of the organization. Historically, that was not a concern. You could, again, we're all friends in the room here, right? You could be a data killer, what we often refer to in the industry. You could be subpar performer for 30 years, but be a high volume subpar performer for 30 years, and have a very lucrative profession, and have a lot of volume for your facility and generate a lot of revenue, but you're actually not, you don't have very good care. Because the peer review standard historically has been one of malpractice, right? As long as you're not harming somebody, we don't necessarily need to do anything proactively about it, but we'll assess it. That's changing in a very significant way tomorrow. We also have litigation with third parties, and you can't, more than 30 states recognize negligent credentialing, and let's be glass half empty about this, or glass half full, depends upon the eye of the beholder here. Let's assume that almost all states will recognize this cause of action, which is not suing somebody because they harmed you. You're suing somebody because they allowed you to be harmed. And so the concept of negligent credentialing is becoming very well understood, and it's getting traction. It's particularly getting traction in state courts. Again, remember what I said about state courts, and layperson judges don't really understand the healthcare industry, but they do understand how to read a law and how to interpret a law. And so they take a layperson approach to interpreting a peer review statute and whether something should be confidential or not. And some states are permitting, where the claim involves negligent credentialing, they're permitting limited or broad access to peer review privileged information because they're not assessing a malpractice claim. We have to keep in mind that public policy changes can have impacts on this. And so a flawed or failed peer review process, and I would expect is for us to see more negligent credentialing claims, particularly against clinically integrated networks and ACOs. The world of corporate responsibility and liability has not caught up to them yet. My guess is it will. It's just so novel that the plaintiff's bar hasn't fully appreciated it. We also have litigation with third parties. I mean, whether it be workplace harassment generated issues where nursing staff is tired of being harassed, undermined, groped, you name it. That issue creates significant hostile workplace environment litigation for organizations. And then we've started to see activity between the relationship between compliance and quality, right? And this case is a couple of years old, but it's representative of where the federal government would like to go. In the Rogers v. Asmat case, and I'll make it very simple for you, this was an action brought by the Department of Justice related to False Claims Act violation under what they refer to as a worthless services standard. In a situation, the whistleblower was a nurse who hospital administration allegedly didn't listen to her concerns about, we have an untrained provider who's harming patients in the cath lab. And the Department of Justice got involved and determined several $100,000 later in a fine that those services were worthless to the federal government and they should not have paid for them. And so a direct connection between credentialing, privileging, and False Claims Act liability. So that failed peer review process that didn't pick up on that for whatever reason has direct liability to it, and we should assume those activities will increase. Also malpractice, and you'll have a great deal of experience with this, but whether information is available or whether you made a good faith effort to correct it can have a substantial impact on whether you're liable in malpractice actions. Litigation with the subject physician. I am unfortunately involved in several litigation projects that are years long, in which a physician is suing a medical staff in a hospital and everybody else under the sun because he or she were removed from the medical staff for quality-related matters, and they had no right to do that. And as long as the litigating provider has deep pockets and they're willing to prosecute it, the legal system we have today will afford them every possible opportunity to prove their case, whether it be 1 year later or 6 years later. And even though the medical staff and hospital may be highly confident that they followed a good faith process to resolve the situation. And you name the other reasons. They go on. And some can be corrected. Some can be corrected real time, but not all. Once the cat is out of the bag, so to speak, there's some things we just can't correct. So assume that if you make a wrongful disclosure, there is a defamation action that can follow. Assume that if we don't follow our bylaws, a breach of contract claim is going to be brought. Assume that if it involves, if you don't employ them and you make a decision, you may submit a professional reference that was something beyond just purely factual or objective, and it resulted in a physician not getting a job, that you'll be sued for tortious interference. Like, you wrote a false or willfully and wanton harmful reference, and that caused me to not get a job, and I think you should be held liable. Good, bad, right, or wrong, the litigation risk is there, and the reasons continue. But I say now's the time to get it right. You cannot turn any switch and enhance your quality program overnight. There's no way you can, because of the cultural issues and the other challenges we discussed. And a lot of it starts with the overwhelming reimbursement paradigm shift that's occurring throughout our industry, whether it be Medicare or commercial. The entire reimbursement framework that your organization is operating under today is going through a tremendous sea change. In its shortest sense, fee-for-service medicine is beginning to phase out among some provider types. We'll always have some component of fee-for-service. I'm fairly confident of that, depending upon various scenarios. But by and large, fee-for-service, meaning do as much as you can, we'll pay a flat fee for it, is starting to phase out. And reimbursement, both Medicare and commercial and Medicaid, is being rooted in quality. CMS has recently announced its overwhelming strategy to transition by the end of 2018, 50% of all Medicare reimbursements to alternative payment models, which like shared savings program, bundled payments for care, comprehensive care for joint replacements, and as 90% of fee-for-service will have some quality adjustment or value-based adjustment by the end of 2018. Put that in perspective. 2 years ago, you virtually had 0% of your organization's reimbursement. There were some one-offs, but by and large, 0% not subject to any type of quality-related adjustment. Now let's interject at this point in time the real appreciation that most healthcare providers operate on single-digit margins every year. You take a single-digit margin, and then now you offset that single-digit margin by the end of the year with a single-digit, or in some cases higher, percentage of your reimbursement at risk for quality outcomes or process compliance. And you can imagine the angst that is available. There are a score of programs that are in place now and under development by Medicare that focus entirely upon value-based quality adjustments to fee-for-service reimbursement. And here are just a few listed now. For instance, the comprehensive care for joint replacement model that hit 66 cities, metropolitan statistical areas beginning April 1. So mandated bundled payments for lower extremity joint replacement. Let's assume that this 66 metropolitan statistical areas extends to 166 and to 266. It is possible that if your organization does lower extremity joint replacement today, that you will be hospitals specifically, it focuses on hospitals, but that necessarily embroils all the supporting providers, will be subject to bundled payments. And bundled payments has a quality threshold associated with it. Now, are you ready for MACRA? And here's why I say are you ready for MACRA? So MACRA is a significant, referred to as the Medicare Access and Chip Reauthorization Act of 2015. It's not getting a lot of love for a host of different reasons, but the purpose of MACRA is pretty straightforward. 3 significant changes to how Medicare pays for professional services. It ends the sustainable growth rate for physician reimbursement, which is no one's been a fan of that for the past several years, and there have been efforts to try to replace it. Well, it's now effectively been replaced, and it establishes in its place a new framework for rewarding providers for giving better quality care, and that's through 2 different programs called the Merit-Based Incentive Payment System and the Alternative Payment Models. I do not want to bog you down in the details or minutia of those, but this is critically important for you to understand about MIPS in particular. Here's what MIPS does. It will streamline today for physician reimbursement, the physician quality reporting system, the value-based payment model, and the electronic health record incentive programs into one program. And it will, through a composite score, it will process physicians' quality and a host of 3 other factors. It will process their payments, and it will adjust them up or down from 4 to 9% over the next few years. And so here's what you want to keep in mind. It is budget neutral. So in its simplest sense, in its absolute simplest sense, for one physician to get a 4% increase in a fee schedule rate, another physician has to lose 4%. And that's probably the easiest way I can describe it, but it is certainly more complicated than that. But because it's budget neutral, the impacts across the board on some organizations will be significant because the composite-based scoring takes quality and process compliance into consideration. So, and here's a timeline, this infographic available from CMS, which describes how this looks. So beginning in 2019, there will be a 4% swing on physician professional services revenue. And again, it's budget neutral. And so the MIPS program will have a significant impact on organizations, and this significant impact can be ameliorated by the effectiveness of your quality program, without question. There are a couple of ways to not participate in MIPS, ranging from it being your first year in enrolled in Medicare as a provider, but probably the largest one is if you participate in an alternative payment model, you get to opt out of MIPS, and you can see what Medicare is doing there, right? They are encouraging providers to participate in alternative payment models, such as Medicare Shared Savings Program, among others. And if they do so, they can opt out of the at-risk approach to reimbursement. And so the reimbursement shift that is underway, you can begin to see, and organizations are slowly getting their head around, how can we elevate overall performance, provider-level performance in our organization in such a way that we properly maximize revenue. Medicare is incentivizing this. They're encouraging us to do this. And so how do we do it? You think we're going to do it on January 1, 2019, we're going to say, okay, we're just going to mandate this year we'll improve quality across the board. You know as well as I do that's not how it works. We've got to start to begin the infrastructure and the attitude and the culture in place, complemented by the processes to get this done. It's not just Medicare. When we know that when Medicare speaks, every commercial payer listens, and commercial payers are more nimble than Medicare for a host of different reasons, and so they have the ability to put in place programs much quicker, and they can be more aggressively adopted. Now, they're purely contractual, but all of these payment programs will emphasize that a substantial percentage of most provider types, reimbursement will be leveraged against some value-based consideration, whether it be quality, minimum quality standard achievement, or process compliance achievement. And so so we've talked about what is peer review and what are some of the challenges, and we've talked about what peer review generally looks like today. Now let's look at peer review tomorrow. Let's look at what it looks like tomorrow, what we want it to look like. You cannot be progressive. There's no way you can develop a progressive quality program if you can't get away from the punitive perception surrounding it. You got to get your medical staff, your physician leaders on board with it. The peer review needs to be, it should be and can be about performance improvement and not just about firefighting, right? Putting out the next problem, the next death on a table, the next case that falls out. It has to be about elevating performance, not focusing solely on performance that arises to malpractice, if you will. You need to align your QA and PI peer review processes around this, and this is vitally important, and I'm just shocked at how most quality programs don't do this. We structure OPPE around Joint Commission or HFAP accreditation standards on the core areas of competency. I get it. That satisfies an accreditation requirement. But our peer review programs should also take a very direct look at what's your organization's quality strategy. And here's what I mean by, you know the commercial payers to which you are subject. You know the Medicare payment programs to which you are subject. What quality programs or what reimbursement do you have based upon process compliance and quality achievement can you track and can use to elevate providers? They should have a direct alignment. We can't just hope that we're going to achieve our quality strategy by relying upon OPPE that's completely structured around accreditation standard. Payer mandated goals and incentives are critical. Have we done everything we need to do to maximize those? Do we look at the things that the payers are looking at? Do we provide education and training around what payers want to achieve? And are we doing it in such a way through a coordinated care arrangement that engages patients to comply with treatment regimens and so on and so forth? Provider employment and services agreements. This is another piece of low-hanging fruit. If I went at most of your organizations and we pulled all the physician employment contracts or APN contracts and PA contracts and we look at the incentive compensation, I bet we are not incentivizing them to achieve what the organization is held accountable to by Medicare, Medicaid, and name a commercial payer. I bet we're not. I bet it's for things, and so we are incentivizing activity that does not elevate the organization. And then the care continuum process. Is our quality program, and I have an asterisk, assuming it can be structured consistent with state law, are we structuring our QA/PI peer review program that captures the entire continuum of patient contact points? Very important. Does your QA/PI program have a substantive performance improvement component? How many meetings have you sat in which we tell this broad swath of providers, we're going to start measuring this next month, or this is what we're measuring, but nowhere in that chronology was we assume you actually know how to maximize performance or competency in that area. We need to complement appropriate measures with how you maximize performance in those measures. And it depends upon the size of the organization, it can be done 100 different ways, from CME to various onboarding type programs and so on and so forth. Also ensure that your governance structure is designed around performance improvement rather than the fallout approach. If we look at a lot of your bylaws or peer review programs or policies, the who looks at something, the committee, the individual, and the process it takes is probably principally focused on investigations around problems. And it's not designed around enhancing performance, it's designed around addressing one-off providers who fail to perform. And there are a host of, I loosely call it governance structure here, but it's basically, have you equipped, whether it be physician leadership, quality leadership, your committee structure, et cetera, your process, your workflow, meant to take into consideration that we're actually focused on improving care and not just dealing with bad care. So there are 3 areas, and I'll move through here pretty quickly, that I want you to consider on fostering effective peer review. So these are some specific areas that you can improve. Make sure your formal process, everybody has a fair hearing plan that's been in place for 20 years. Make sure it's designed in such a way to enable you we want to be on the positive side, not on the negative side. This should not be purely punitive, but we can't have your quality people making up what they do. We can't have the chief of staff, president of the medical staff, department chair making up what they do, and I too often see them being stuck with having to make up how they deal with quality issues. Let's give them a delineated process that they can follow and make it easy on them, and that even includes the corrective action process. I'd like to think that we can avoid corrective action in most scenarios if you deal with it early and often. Let's talk about education. I touched on this a minute ago. Your peer reviewers need to understand the rules of the road before they get going. I'm dealing with a complicated situation now where, in good faith, physician leadership went down a 6-month road of external peer review, and we came on board towards the end of that process and discovered none of what was followed, set forth in their policy, was followed. And it's created a little bit of challenge for us to have to deal with. And that happens probably more often than you can imagine. Make sure they understand the process before they dive into it. Understand immunity is not given. You got to recognize it has to be earned. And so we need to dot I's and cross T's and make sure that there's at least general education available to the medical staff and the pertinent committees around what best practices are, et cetera. Documentation. I can't emphasize enough that today it's more about trending cases. So just as with general litigation and solid peer review, documentation can be critical. I don't care if it's an incident or it's an event. You have a hallway conversation with somebody, send them an email, of just a plain spoken email. Bob, thanks for meeting with me. I'm glad we're on the same page for how we're going to deal with this. I cannot begin to tell you the value of a 2-sentence email 3 years from now. We got to make sure we appropriately document things throughout the process. Label it. Too often we label everything confidential and peer review because we feel like it is, even though the process doesn't comply with it. So the label will never get you the peer review privilege. But ensure, though, that you label it because it evidences intent and allows you to better segregate administrative non-privileged data from privileged data in the long run. And peer review committee minutes should be carefully drafted. Too many times I see committee minutes that are narratives and they're more like a transcript. Committee activity is about the committee. It's not about random individual physician comments, which can be captured out of context. Make sure your committee minutes make sense for the circumstances at play. If you want to be progressive with your quality program and address some of the reimbursement issues we talked about, you have hurdles. Virtually every law that governs the healthcare industry today, aside from subtle modifications and updates and changes, were written 20 years ago. Right? State peer review statutes, by and large, are 20 years old. Only a handful of states have contemplated the concept of networks and ACOs, for instance, in their peer review sharing process. Most don't contemplate it, so it's an at your own risk type of approach. The Medicare conditions of participation are, in many respects, although Medicare strives hard to update them, they're outdated in many respects. They're not where the industry is at today, and that means the hospital licensing requirements are. And because those are outdated, that means the accreditation requirements can also be outdated because in many respects they rely upon Medicare conditions of participation for their viewpoint for deemed status purposes. So understand, if you want to get progressive, you will have hurdles or you want to make informed decisions around where we think that's a low-hanging fruit and we think the State Department of Health doesn't care, so we're going to do it. Or we've gotten a waiver from the State Department of Health. You've got risk management issues, right? We have a billboard effect. Every 6 minutes you see a billboard in your city that says we're the best at what we do. We have to understand when we emphasize quality, we almost invite additional litigation and risk management risk. Know that as you proceed. Does your process consider the current view of negligent credentialing in your state? For you 33 states that recognize negligent credentialing, do you understand how those relate to your quality program and how you might have to segregate information? Understand the political and business risk with forcing change, and you experience it every day. Hospitals and healthcare industry organizations are highly political entities, good, bad, right, or wrong, and you have to make informed decisions as you go through that process. So I'm gonna leave you with this last, and I can't emphasize it enough. You can have policies all day and night, but what's most important about policies is that you get on board. You get a buy-in, and you get a buy-in around how you're going to enhance your quality peer review program. And the best way I can show you to do that is to model the direct benefits. Under Educate, 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 notice that I've outlined model the direct benefits of improved quality. We can actually take a physician's conduct and performance, and we can model it against what the Medicare incentive payment system, the merit-based incentive payment system is going to look like, and we can diagram and visualize for providers in this day and age with value-based reimbursement what your care will look like in 2018, 2019, 2020. That's probably the best way to start to get providers on board with an enhanced peer review process that takes into consideration 2016 and beyond principles. I'm going to leave you with a host of takeaways here. We are at our time, and I understand these materials are available to you. These takeaways are concepts that I've touched on throughout our discussion today. Be sure and look at those, and do not hesitate if you have any questions in the Q&A section, or do not hesitate to follow up by me with email, and I'll be sure to respond to you right away with a good response. So at this point, I'm going to turn this over to Callie.
Thank you so much, sir. If you could advance to the next slide for me and hit play. Oh, too far. There we go. Oh, right around the bottom, you should be able to hit play. Or right around the bottom of the, see the second blue bar? Oh, because it's a video.
Gotcha.
Oh, it looks like we're having some issues there. So everyone, we want to talk about how this topic applies to Simpler. We offer a host of provider management tools, whether it be from your peer review process to your payer enrollment to your provider privileging and your provider credentialing. You can reach out to us at sales@simpler.com. That's sales@sympler.com. We are going to post a quick poll just to see why y'all joined us today before we move on to the Q&A. Once you answer this question, it will then put you back on the Q&A screen. We would appreciate your feedback. We did have a couple questions roll in. Let's try and answer 2 or 3 here real quick while everyone does the poll. The first one that rolled in, how would a nurse who oversees the PR process find the state law?
So let's start with this. So there are a number of different ways to find a peer review statute. There are, and if you want to, what might make the most sense rather than ask you to kind of navigate your state. So every state has a website where they maintain the official record of statutes and regulations. That's where it would be housed most directly. I mean, there are a host of different ways to find it. If you want to email me the state, I'm happy to send you a link to your state's peer review statute. What's important to keep in mind, if you're an advanced practice nurse or a physician assistant, you may or may not be bound by, subject to, or be able to take advantage of your state's peer review statute because they all define what a healthcare provider is. And it almost inevitably includes a broad listing of provider types. But I encourage you to make sure that you are a healthcare provider as defined in that statute.
All right, thank you so much, sir. And because we are out of time, I'm going to apologize for everyone that we didn't get to your questions. I will be sending these over to Brian so he can reach out to you with answers. If you do have any more questions, you can either email Brian or you can email us at Simpler at communications@simpler.com. I wanted to let everyone know that a recording of this webcast will be archived on simpler.com soon, and you'll be able to download the slides. If you're wanting to receive this email to make sure it doesn't go in your spam, please add communications@simpler.com to your address book. We will be sending along your CE certificate in a separate email as an attachment, so please make sure to add us so we don't end up in your spam folder. Is there anything you'd like to say in closing, Mr. Brian?
Everybody, thank you for your time today, and again, don't hesitate to reach out to me with the questions, and I'll be sure and follow up.
All right, thank you so much, sir. And once again, thank you to everyone who joined us today, and we hope to see you next time. We are posting which webcasts are happening on simpler.com, so please check it out, and we hope that you join us again. Thank you all, and have a great day.